lot of our clients do come to us. They either say, I want to get this over with, or I want to get what's fair. That's really the two positions that they come from. This is coming at me and I want to get it over with, or I want to take it against somebody and I want it to be fair. In my opinion, it's not whether our client is wrong. It's not quite that black and white. Maybe they've done some wrong things, but not all of it's been wrong. And that's kind of, Kevin talked about developing leverage and setting ground rules. And that's kind of what goes into it. You're sort of placing like, all of this was right and this was not right. And that's, you got to work with your opposing counsel on that, because that's usually each side brings this exact layout of columns, at least in my opinion, where their clients too have done something right and something wrong. And that is like getting to the middle, getting to something that you can live with. We were talking a minute ago, one word that comes up in my house, because I have young kids and they're always like, that's not fair. That's not fair. We say, good parents say, life's not fair. But a lot of our clients do come to us. They either say, I want to get this over with, or I want to get what's fair. That's really the two positions that they come from. This is coming at me and I want to get it over with, or I want to take it against somebody and I want it to be fair. So kind of going back to that, usually each side has done something good and something bad. I can't think of a single client where like, woof, that was just all bad and all here. There's usually, and let me define bad. It's doing probate, not everybody does probate all the time. Some, when their parents die, that might be the first probate they ever touched. So to say that was bad, like, well, it might be bad in my opinion, because I've done hundreds of them now. This is your first one. So bad's on a sliding scale here. You did something that you didn't know that you weren't supposed to do. And now we got to get this presented to the other side so that we can all arrive at what we can agree is fair enough, because like my 13 and 8-year-old, nothing's ever going to be fair enough, or like fully fair, but we can get to fair enough between the two of them.
When you have a client whom you suspect was actually the bad actor, or was more of a bad actor than the rest of the constituents, it's kind of similar to when I was an investigator for the Public Defender Service in DC. Even if they actually did commit the murder, they still deserve a vigorous defense. Now, in this situation, typically nobody's been murdered, although we have had cases where someone was. But in these cases, it's more of a mitigation process. You want to do the best you can for this person, knowing or suspecting that they were probably the bad actor, but your posture becomes a lot more conciliatory, because if you know that your person may have done, the wrong thing, then it's your job to help mitigate that situation as much as you can and get to as fair a position, to echo Elise, as fair as a position as possible, because you can't make the bad thing go away. Essentially, you're sort of trying to help the other family members to get to fairness, even though you're representing this person, and you still represent them vigorously and to the fullest extent. But as with all of these matters, it's a process, and you're trying to get to a collective resolution, and you just have to sort of take what you know and move forward and try to get to the family resolving it.
Collectively here, I hear us, we're both sounding a little bit like the fairness police. I also want to include the disclaimer that the probate court, which is where the vast majority of these would be litigated, not all, but most, the great majority, the probate court's trying to get to fair too. So we didn't just come up with this get to fair, or fair enough, or an acceptable level of fair concept. That's how I can't think of a single judge in the state of Georgia that doesn't rule trying to get everybody to fairness. The difference is, do we let the judge decide on what is fair, or do we help the clients decide what they think is fair? So, and a lot of these, it's both. Like we try to work with just the clients to help them get to a place that they think is fair enough. And if they still can't do it, the court's going to do it. And it's not an on or off, black or white with the judges. They are trying to get everybody to a position that they think is fair and within the terms of law.
Yeah. And that Elise makes a really good point. People clients very often say, well, what's the judge going to think about this? And I respond, the judge is very unlikely to pay any attention to your case until and unless we have some sort of hearing, a trial, whatever. So we're essentially on our own at this point, and you need to work to get this resolved without going to the judge. And 99.9% of these cases get resolved at mediation or otherwise. And I always tell clients before the mediation, this is your last chance to control the landing. After this, somebody else is going to decide your case. And if you want to be the person who has agency in deciding what happens in this case, you need to resolve this here instead of going to court where somebody else is going to decide. So that is mostly what happens. And, people come to us thinking there's going to be some, big Perry Mason moment, a dramatic trial, and it's not. No. It's an administrative process. It's a lot more boring than it is on TV. The attorneys are not as handsome as they are on TV, and the cases don't resolve in an hour.